Right, this is case number 22190286. This is Credit Acceptance Corporation versus Joaquin Cinto Miguel, or I may have it in the reverse order. All right, the matter is before the court, set up for a hearing on today's date as a result of the defendant having filed an answer in this matter. Your appearance for credit acceptance, please.
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, T75722. How are you today?
Good morning, Your Honor. This is I'm the Spanish interpreter for the defendant. Do I need to be sworn in first, or can I go ahead and call the case?
What I need you to do is anytime you're in front of me, it's important for you to wait until I ask you to speak up.
Okay.
Okay. All right. Given that you have given us your name now, you indicate that you are here as an interpreter, and that is for the defendant in this matter. Is that correct?
Correct.
And you are interpreting from English to Spanish, Spanish to English. Is that correct, counsel, ma'am?
Correct, Your Honor.
All right. Is there any attorney that's present for this defendant? If you are on this Zoom, please say something at this time.
¿Hay abogado para el señor Miguel Jarquín Aniceto?
All right, and Madam Interpreter, if you'll raise your right hand to be sworn at this time, you do solemnly swear that you will interpret the truth in this matter from English to Spanish, and Spanish to English to the best of your ability, so help you God.
I do.
All right. And so good morning to defendant Miguel. Are you present today, May Counsel?
Señor Miguel Joaquín Aniceto, enciende su micrófono. Turn on your microphone. Okay. ¿Usted está presente?
Sí, aquí estoy.
Yes, I'm present.
All right, thank you. Thank you, Madam Interpreter. All right, so I did receive the answer to the complaint. Actually, that was in August.
Yo recibí la respuesta del demandante de agosto.
All right, and it does not seem to really protest or contest the complaint in this matter.
Y parece que no está en contra mucho de el demandante en este asunto.
So let me now hear from the plaintiff's counsel at this time. So,
Ahora quiero escuchar el abogado del demandante.
Your Honor, I'm happy to report that I spoke with defendant and the interpreter in a breakout room. We've come to a resolution. I will be sending paperwork that will conditionally dismiss the case to defendant, and he will sign it and return it to me, and I will file it with the court, and that'll end the case as far as the court's concerned.
Su señoría, yo quiero decir que nosotros en el cuarto de privado llegamos a una resolución y yo voy a mandar los papeles y él los va a regresar con la firma para que este asunto se pueda resolver.
Sí, estoy de
Yes, it's fine.
right, it does appear then that there is an agreement that is reached in this matter that will involve a conditional dismissal.
Entonces parece que hay un acuerdo en este asunto que va a llegar a un renuncio en este asunto.
The court will await that order, and that should resolve this case.
Entonces vamos a entregar este orden y esto va a resolver este caso.
Thank you, Your Honor.
Gracias, su señoría.
Gracias.
Thank you.
Thank you, sir. Good day to all.
Take care.
Thank you. Se puede ir, ya se acabó. Gracias. Okay, thank you.
One moment, everyone. All right, the court now calls case number 22191511. This is Albee Indy Funding LLC versus Donald Gay III. Matter is set on for a hearing on today's date regarding scheduling and status in this matter. I did receive defendant's answer regarding this matter. Your appearance for the plaintiff in this case, please.
Yes, good morning, Your Honor. Gavin Gray, P79819 for the plaintiff, LVNV Funding.
All right, thank you, counsel. Good morning to you. I'm looking now for Mr. Donald Gay or any person representing Mr. Gay. Say something at this.
Yes, this is Donald Gay here.
All right, thank you, Mr. Gay. Good morning to you, sir.
Good morning, Your Honor.
So it looks like, as I reviewed this matter, that the claim here is that there is not a contract existing between the parties, and that therefore the defendant asserts that he has no liability in this matter. It looks like the complaint that was filed in this matter is a complaint that alleges a contract that was assigned to the plaintiff in this matter in the ordinary course of business. All right, let me hear from counsel for LVNV, and then I'll come back to Mr. Gay.
Yes, Your Honor. I believe we included the exhibits as well. We're also claiming an account stated. It's it's a basic collections account. I haven't had an opportunity to speak with the defendant in a breakout room, and if he's willing, I'd be more than happy to try to discuss this with him in a breakout room.
Well, that does make sense, and I'll stand down so that you all can have that discussion. And when you're done, just come back into the courtroom. So I'm going to send you a notification to go to breakout number 1. And counsel, there is your notification, Mr. Gay. I'm sending you a notification as well. And just come back into the courtroom once you get your discussion. All right, see you real soon. The court now calls case number 22-192-504. This is Gardner Properties and Management LLC versus Maria Bernal. Matter is before pursuant to a status conference. I think I set I set this up for a status conference and scheduling conference. Your appearance for Gardner Properties, please.
Good morning, Your Honor. Hamza So on behalf of Gardner Properties and Management, P2080.
All right, and do I have Maria Bernal on this Zoom? Say something at this time.
Yes, hi, good morning. I'm Maria Bernal's translator. I'm her daughter, Isabel Pardo.
All right, thank you. And what's your name? The daughter's name?
Isabel Pardo, ISABEL. First name Isabel, last name Pardo.
All right, got you. And Ms. Maria Barno, you are present in this matter as well. Is that correct?
Dice que si eres presente.
Yes,
So what you're indicating to me is that she does not speak English fluently.
Correct. She's not fluent in English.
And do you have any certification, ma'am, in providing interpretation services at all?
No, I do not.
We may have to address that. Counsel, let me hear from you, sir. What's going on here?
Your Honor, this is a breach of contract case. There was a previous landlord-tenant matter that judgment was issued on. Collection activity happened on that judgment, and an amount of the total judgment was collected. There now remains a past due balance of $3,418.51. I looked over the defendant's answer, and she claims that the collection activity that undertook on her account, the garnishment, should have had paid the entire amount. The amount she lists is $2,000 and some change. But the total judgment amount that was issued in the landlord-tenant matter was upwards of $5,000. So that's the discrepancy in our positions.
Yeah.
So what you're attempting to do is to seek a civil judgment for the difference between what was collected under the landlord-tenant judgment and what remains. Is that correct?
That's correct, Your Honor.
All right. I think what I'm going to have to do at this point is appoint a court certified interpreter to assist Ms. Burnell, because her daughter is assisting her, but she can't do that because she's not certified as an interpreter that I can put under oath. So what I'm going to do is I have to set another date for that. Let's see how soon we can get that done.
Your judge, if I may, what they're saying is incorrect, because they actually garnished all of that from my previous employer. They received the full amount. I'm no longer with that employer, but I have contacted them to get that. My mother was on the lease as a co-signer, and they've already received the full amount. In addition to my checks being garnished, they also took it out of my taxes, my husband's taxes, who was not on the lease and did not live in the property at the time because we were separated. This has been ongoing since 2019. I don't understand. And in addition, they actually have a court case against me through Ellen Park yet again, and I will be doing the same thing.
Okay, I appreciate what you say, but that sounds like you might be a witness in this case. This case is not a case that's against you. This case only has Ms. Burnell as the defendant in this case. So you may be, which is another major reason why you couldn't be an interpreter for Ms. Burnell. So I'm going to appoint an interpreter.
Could you request an attorney?
Don't interrupt me again.
I apologize, sir.
You can ask whatever you want to ask, but you can't ask it while I'm talking. You almost noticed that when you just went off talking and talking and talking. I did not interrupt you. And I don't know why you think that you can interrupt while I'm talking. That really seems kind of strange to me. Let's keep it dignified. You can't do that. Basically, what you had to talk about earlier was not even relevant to the proceedings. But because you started talking, I'll let you finish. When the court is talking, I don't know what causes you to believe that you can interrupt me when I'm talking. So what we're going to do in this case is we'll set it up so that there's an interpreter for Ms. Burnell. It appears that the young Ms. Burnell also the other young lady, the daughter that there may very well be a witness in this case. So you could certainly come back as a potential witness regarding events that may have occurred in this matter. So I'm going to give you a new date. And we're going to sign an order for an interpreter. I did overhear the question regarding the appointment of a lawyer. In a civil case, the court does not have the authority and the resources to appoint a lawyer. You may want to check with one of the service agencies, and one of those agencies may be able to provide legal assistance, but that's not something that the court does. So you'd have to look to some type of legal service agency that might make resources available to you. In a criminal case, the court appoints lawyers when a person is charged with a crime, not in a civil case. So there's no system for doing that. All right, so the next action date in this matter is going to be the 9th of February. I'll make it 2/9/23, and that's going to be at 9:45 a.m. We will have a court-appointed interpreter to assist Ms. Burnell in this matter, and I expect that the other individual will be back as a witness regarding this matter as well. I do wish you well. Good day to both sides. See you on the 9th of February.
Take care. Have a great day.
You have a wonderful day.
All right, likewise. All right, the court now calls case number 22-24-301. This is Jerry Johnson Jr. versus 656 New Center Portfolio or Portfolic. The matter is before the court, set before the court as it relates to a claim of appeal, strike that a small claims matter that apparently was appealed to this court. Do I have on this Zoom Jerry Johnson Sr.?
No, Your Honor. My name is Mary Mahoney, P41568, appearing on behalf of Mr. Johnson.
All right. Good morning to you, counsel.
Good morning, Judge.
Thank you. Do I have someone regarding 656 New Center Portfolio?
You do, Judge. Nicholas Lefevre, P62897, appearing on behalf of the defendant, New Center Portfolio. Judge, this one is a little strange on the docket. And I've spoken with Ms. Mahoney about this as well, because her appearance was filed back in October. I timely removed this case, filed a demand for removal from small claims. I timely did that. I timely filed an answer. Nothing was heard in small claims. This was a removal on my end that was timely performed. When I look at the docket, I'm not clear at all how this would have been even entered as an appeal or anything like that. I just think this is some type of an error. This is the first time we've ever been in front of the court on this case. So, I mean, if in all likelihood, it's better style as a pretrial or an initial pretrial or initial status conference, because I'm mystified in how this would be treated as an appeal. Unless there's something, of course, I don't have that was filed with the court that perhaps Mr. Johnson may have filed before Ms. Mahoney was involved. I simply don't know.
I agree with Mr. LaFever's statements that he just made, Your Honor.
Thank you. And I'm looking at the I'm looking at the register of action regarding this matter, and clearly this was a removal from the small claims division, and somebody superimposed on that the notion that it was an appeal from that division. The court then would indicate that the court will treat this matter as a pretrial conference and will strike any indication of this being an appeal from a small claims determination. All right.
We appreciate it, Judge.
Absolutely, absolutely. That's the right direction for this to go.
Your Honor, yeah,
Go ahead,
Mr. I'm sorry, Judge, I don't mean to interrupt.
Go ahead, ma'am.
Mr. LaFever and I did speak at length last night, and we talked about our clients' relative positions, and we talked about where we need to go with the case. I believe both of us are going to work proactively to try and obtain a resolution. There's one housekeeping matter. The invoices in this case were directed from an entity known as KO Plumbing, which is actually a valid Michigan limited liability company. And because Mr. Johnson had initially attempted to handle this matter by himself, I'm sure that he believed that in small claims court, perhaps it didn't matter whether he filed it in his individual capacity or on behalf of the company. So as a matter of housekeeping, I would simply like to amend the complaint to make note that it is KO Plumbing that is suing for the damages here. To that end, I think Mr. LaFever and I are perfectly fine with about 60 days of discovery so that we can exchange some documents and photos. And then he and I are going to, again, proactively discuss this matter, try and get our clients to move a little bit more toward the middle, and we may in fact be able to achieve a resolution.
Right, Mr. LaFever, it sounds like about the size of this at this point.
That is correct, Judge. Everything counsel just said is correct. And I don't have any problem, assuming the court's willing to accept it. We'll just produce a stipulated order amending the plaintiff to KO Plumbing as opposed to Mr. Johnson. And we'll submit that to the court for entry, but we'll do that by stipulation if the court has no objection to that. And otherwise, the dates are fine. The schedule generally is acceptable that she wants.
All right. So KO Plumbing, how is that? Is that K and O and then plumbing, or is that something a little different than that?
It is the initial K, the initial O, Plumbing, Contracting, and Sewer Cleaning Service, LLC. It does go by an assumed name of KO Plumbing.
All right, got it. So that I will issue a scheduling order in this matter, allowing for 60 days of open discovery. That is going to take you up until the return date in this matter. That will actually be just beyond 60 days. So that's going to give you until the 9th of March of 2022. That's when you're coming back before this court. That's going to be at 10 o'clock a.m. The 9th of March 2023 at 10 o'clock a.m. The scheduling order will include the language allowing for the amendment of the caption as it relates to the plaintiff's matter. So in my scheduling order, there will be a part that allows the change as it relates to the plaintiff's name, and you will receive then the scheduling order that allows for discovery with the new court date, also that allows for the filing of any motions that may come up in the interim. If you have a motion that's positive or otherwise that you want to get heard right away, you can have it heard on the date of the next pretrial, which is the 9th of March, as long as you file your motion and allow for at least 10 days for the other side to respond. So if you file your motion, set it for hearing on the 9th, as long as you allow the other side at least 10 days to respond to this motion, I will hear it on the 9th. And that will be under provision number 6 in the scheduling order. This does not preclude me setting motion dates in the future, but this is just a helpful along the way. You can go ahead and use that device. It doesn't preclude future filing of motions if that becomes something necessary. All right. So you'll get an order from me in the mail in the next few days, including KO Plumbing as the plaintiff in this matter in the place of the present plaintiff, and providing the dates as set forth in this record. All right. I wish you well. Good day to both sides.
Thank you, Your Honor.
Thank you.
And I'm back to LVNB funding versus Gay under the suffix 1511. Thank you for your patience in this regard. Thank you for taking the opportunity to speak in the breakout room as well. Council, update me, if you will, at this time, sir.
Yes, Your Honor, we definitely were not able to come to any sort of resolution in the breakout room. At this point, I request 60 days discovery, and it's likely we'll be seeking to resolve the case with a motion.
All right, very well. Mr. Gay, anything you wanted to bring to my attention at this time, sir?
I would request the case be dismissed because counsel cannot provide a contract with my acceptance or agreements on it. He can't even provide a contract with my name on it. I mean, he's had ample amount of time. He's had months to come up with a contract that shows that I have an obligation to perform on a debt with LVNB Funding LLC. Months.
All right.
And that's all I have to say, Your Honor.
Yeah, those are the kind of things that are resolved by way of motions. And so I will anticipate that a motion will be filed addressing those issues. And I assume based upon the documents I looked at that this is an assignment from one entity to another, but all of that will come up in a motion. So I'll go ahead and send it over, putting it on a scheduling order for 60 days. I'll set the return date on this matter for the 13th of March, March 13, 3/13/23, and that's going to be at 9:30 a.m. That's when you're coming back to see me. And in the interim, you will have the opportunity to exchange information, any items of discovery that you wish. You can take care of that during that 60-day period of time. This order also provides an opportunity for the parties to file motions with this court and have your motion heard on the 13th. The only requirement is that you allow the opposing party at least 10 days to respond to the motion that you set for hearing on the 13th. You set your motion for hearing on the 13th, I will hear it that day, as long as you allow the other party to have at least 10 days to respond to the motion. Right? You'll receive my document in the mail in the next few days. I wish you well to both sides. Good day.
Thank you very much, Your Honor.
Thank you. The court now calls case number 22190497. This is Beaumont Health versus Gilda L. Cox. The matter is set on for, looks like an initial hearing. The court did receive, looks like an answer to this matter. Well, let me get counsel on the record regarding this matter. Court plaintiff.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
All right, thank you, Mr. Burke. Good morning to you. I'm looking now for Gilda Cox. Ms. Cox, if you're here, say something at this time. I see someone talking, but you must be on mute. I can't hear you. So if you're hearing me, Ms. Cox, turn up your speaker or something. I'm trying to hear you. I don't hear anything. Still can't hear you. If you are Gilda Cox, wave your hand at me, please. Okay. Good morning to you, ma'am. For some reason, I'm not getting any sound from you. It could mean that you need to turn up the volume on your device.
Your Honor, as you're doing that, I was able to hear her in a breakout session and we did resolve the case, if that helps.
All right. And so what's going to happen as a result of that, counsel? You're sending in some type of order, is that correct?
Yes, with your permission, we're preparing a consent judgment for Ms. Cox to review. I do have her email address. It will be sent, if not today, by Friday. Would you consider 20 days for me to get it to her, for she to get it back to me and get it to the court for your signature?
Yes, I'd like to move faster than that. Ms. Cox, you've heard the discussions here. You've reached an agreement regarding the entry of a consent judgment in this matter, ma'am. Is that correct? Wave your hand if that's true. Because for some reason, all right. And she's waving her hand indicating agreement in that regard. For some reason, we're not able to get her audio today. All right, so I'm going to mark the file as having been resolved by the parties, and I will await a signed and agreed upon consent judgment in this matter. So the file will be marked awaiting a proposal. I wish both sides well. So
Thank you.
As soon as possible, Mr. Burke.
I will. Thank you. Have a great day.
Great day to you. Great day to you, Ms. Cox. And I'm coming right to you on the Jones-Anoa matter. In just one moment, let me address always on time transportation versus City of Detroit. And then I'll be right back to the other matter. This is case number 22-187916. Always on time transportation versus City of Detroit. Your appearance for plaintiff regarding this matter, please.
Good morning, Your Honor. Christina Abro here on behalf of plaintiff, always on time transportation.
Thank you, Ms. Abro. Good morning to you, ma'am. For City of Detroit, please.
Good morning, good new year, Your Honor. Chris Michaels, P83156 on behalf of the city.
Thank you, Mr. Michaels, and good morning. Happy New Year to you as well, sir. All right, so looks like, did I see where you all had some discussions this morning in a breakout? I thought I saw that. Maybe I'm mixing it up with something else. All right, so where are we with this matter? I know it's been up a couple of times.
Actually, Your Honor, I believe this is the first time we're in front of you. It got rescheduled a couple of times, unfortunately.
That's correct, Judge. I believe it was up in November or date somewhere around there, and it was adjourned to today's date. So this is the first pretrial.
All right, got it. All right. I know I came across this somewhere. Okay, got it. All right. How are you making along this grid of trying to decide whether or not this is something that can be resolved? Some discovery might help in that regard, I'm presuming.
Yes, Judge, I believe we can exchange initial disclosures and try to get this wrapped up. It's not a huge bill. It's under $10,000. I think we just need to conduct some type of discovery and then we can just get it settled.
And I, just by way of information, I agree. A little bit of discovery would be nice, Your Honor. There is an underlying claimant who has a case in circuit court. The city does have some questions of these bills just because of the nature of the alleged injury. So a little bit of discovery would be nice. It is not a big case, but it is connected to one that is quite a bit bigger and has some serious issues.
Got it. All right, sounds good. I will go ahead and set it on a pretrial scheduling order, which you'll get from me in the mail in the next few days. Your next date is going to be 3/13/23 at 9:45 a.m. And discovery will be open through that date. The paragraph 6 in that document also gives you the right, the opportunity to file motions if you wish to have them heard on that date, with the only requirement being that you allow the other party at least 10 days to respond to any motion. and I will hear it on the 13th if you wish to do it that way, dispositive or otherwise. Indeed, if there are discovery issues that have come up, then you would want to put that in a motion and set it for hearing on that day. And again, the court has streamlined the time, so you file it as long as you give the other side at least 10 days notice out here. All right, anything else?
Can you,
Judge,
can you repeat the date? Oh, sorry.
I apologize. I was just going to say, can you repeat the time?
That time is going to be 9:45 a.m., 3/13/23, 9:45 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you all. All right, this is case number 18-241991. This is Jones on Owanu versus Reina Alradi. I believe there may be an et al regarding this matter. The matter is before the court. I have it set on for review on today's date, and of course, this is the case to determine whether it gets resolved first or do I retire first. Which
yes, Your Honor. Good morning, Your Honor. David Palmieri for the plaintiff, P26796. I know Mr. Elkins, my friend, wants to put his appearance on the record, and then I'd like to address the court, please.
Good morning, Your Honor. May it please the court. Michael Elkins appearing on behalf of all defendants. My P number is 29725.
Thank you, counsel. Good morning to both of you. Happy New Year.
Your Honor, yes, Your Honor. Thank you very much. And thank you for your patience with us. You put this over to today because we were told that the vehicle had reached Nigeria. The vehicle was in a container. The container had been freed from the bonds of the tax department over there and was able now to be opened. And we were asking the parties, Nigerian representatives, to get that vehicle out of the container, get it to the hands of my client's agent there, Mr. Chijoki. I'm sorry, I lost his last name. About that time, unfortunately, Your Honor, and this is, I'm taking all this on myself. I had a health issue that put me out of commission for about the last 2.5 weeks. I'm aware that during that time, Mr. Elkins tried to call me. I did not return his call. My client also tried to call me. I did not return his call. So this is entirely on me. I am subject to the discipline of the court if after the hearing the facts you find that necessary. I won't squawk. This is an old case. But I was unable to participate for that period of time, and it turned out to be a crucial period of time. What I find out this morning is that apparently our representative was under an instruction to tell the other side, go ahead, get the car out and bring it to us, and give an address where that could be done. The other side's representative was under an instruction to wait for us to come to the container so that it could be opened in the presence of everybody. And since no one communicated different instructions, the parties, the minds of the parties, as they say, never met. Consequently, as I understand it, I could be wrong. The car is still in the container, still waiting for the Nigerian representatives to go open the thing and inspect the car. And again, the delay in this case is because of my health condition and probably nothing else.
How quickly, before I go to Mr. Elkins, how quickly can we try to bridge this together? I know Mr. Oweno has been waiting, what have you. So I want to say, when a person is ill, all kinds of things get kind of discombobulated. I think we all know that. Maybe Mr. Elkins can tell me. Go ahead, sir.
Well, Your Honor, first of all, I'm sorry to hear about Mr. Palmieri's illness. Second of all, we did reach out. With the container is ready to be released as we speak. We wanted to have Mr. Oweno's representative present when the container was opened, so that there'd be no argument about how the condition of the vehicle when it came out of the container, which I thought was prudent on everybody's part. With the, from the time the container is opened, I am told it can be moved from the port on Tin Can Island to the place where it can be picked up, and that could be done within a week. That requires trucks to be scheduled and what have you. So as soon as we can get a date and time for Mr. Orlando's agent to meet our agent, we can get that, have the opening of the container, the examination of the vehicle to start with, then it can be removed from the port to the place where it can be picked up within a week.
So you're saying, well, here's where we are. I know the case has been going on a bit. I want to help. I want to do what I can to get it to some type of conclusion. I mean, I'll hear it again this week or any day next week or any day the week after that. You can pick a date, or you can, or I can leave it open-ended for you guys to go ahead and work out the details and come in on any Zoom day, and I'll make space for it. That's where we are with this. I'll figure. I'll make space for whatever you need to do. So I'm not going to put it out 30 days or anything like that. I mean, you know, I can put it a couple of weeks out if you want to do that, or I can leave it in any day, Monday through Thursday. You could come in on the Zoom, and I'll know why you're here. I'll keep this file in front of me. So whichever way, what do you prefer? I can set a firm date, or I can. You guys, you seem like you're not having a problem working together. I just this illness thing was a problem.
Yes.
Somebody,
Your Honor, I am free of that impediment at this point. I don't expect it to recur. And so if you would please set this for a similar conference 2 weeks from today at the same time, 10 o'clock, we will move heaven and earth if necessary to get this case moving.
all right. So that, I can do that. I can set that for the 19th, and that'll give you a couple of weeks, and then we'll come right back at 10 o'clock on the 19th and then see where this case is at that time.
Michael,
At 10 o'clock?
Yeah, 119 at 10 o'clock a.m.
This requires Mr. Unwiner to have his agent contact our agent. I have forwarded the contact information to Mr. Palmieri a number of weeks ago.
that's true.
And I see that Mr. Jones Owenu is raising his hand. You're represented by counsel, so it's kind of hard to do it that way, to have you to speak. Mr. Palmieri, what do you think, sir?
I believe that what Mr. Onwenu wants to tell you is that the contract was that they would deliver the car to his agent at the location in Lagos, Nigeria. We don't really need to be present when the container is opened, although I do understand Mr. Elkin's prudence on that in wanting all parties to be there when the vehicle first sees the light of day after 6 years. But Mr. Onwenu is shaking his head. Apparently, he doesn't feel that that's necessary. And so if I could give Mr. Elkins an address to which the car could be delivered, I can do that very, very quickly. And if he will go ahead with his client and have that done, we'd be fine.
Without getting.
Well, let me just say this, from the court standpoint, after that number of years, I want to cut off any additional litigation that might occur. And one of the ways to do that is for the parties to at least be able to nail down what the condition of the vehicle is at a certain point in time. And that just seems to be prudent to do it that way. Now, I know that that Mr. Oweno does not want to waive any defects that might exist regarding the vehicle. So it probably is prudent for someone to be there to take a look at what the condition is at a certain given point in time and document that. And then there's no dispute. I don't think there's no dispute that Mr. Elkin's client has to deliver this vehicle to the requirements under the contract.
It's not actually in the contract, Your Honor, and that the contract is really simple. I don't have it in front of me, but it's a simple one-page document. It just says shipment to Nigeria.
Michael and I will hassle that out with the court's
Well,
permission. I'm sure we'll
absolutely.
come to a resolution of that. I do understand the court's concern. My concern is that if any part of this does actually go to trial, that it's a bench trial, and not doing what Your Honor wants done would seem perilous under those circumstances. So I am recommending to Mr. Onwenu that we have that mutual opening attended by our people.
I'm satisfied that the approach that the parties are taking at this point to make sure that the property gets into the right hands and to document along the way what the condition may be after a substantial period of storage is important to this process. So I'll again take another look at everything on the 19th.
Yes, Your Honor.
Along this grid at that time. All right, I do wish you well. It's good to see everybody. Again, Happy New Year to you, and I'll see you on the 19th of January at 10 o'clock a.m.
And also, Your Honor, healthy and Happy New Year. So,
we appreciate you, Judge, and have a good Happy New Year.
yeah.
Thank you. Thank you. All the best to each.
Thank you.
I'll give you a call, David.
Yes, sir. Thank you.
All right, I have other people on this Zoom, and I don't have any other cases regarding today's date. Please, Alcatel, Joy, Tab, whoever that is, say something to me.
How you doing?
Yeah, who am I talking to? How are you?
Laurice Barber. I had a pre-trial meeting today, and they kept sending me to different courts for the Zoom.
Yeah, what's the case number?
The case number is 22194-469.
All right, just one moment, ma'am.
Okay.
Alicia Jones Coleman, Zoom number.
Yeah, that's Judge Jones Coleman's case, and her Zoom number is 360-534. Zero.
Okay. Okay, let me write that down. Say that again.
That's 360-534-0000. And also let me give you her courtroom phone number, okay?
Okay.
965-2404.
2404.
Yes.
Okay, because this is like the third one.
Yeah, there was some confusion because of some switches that were made recently. So that's her case, and sometimes some of her cases are getting routed to me, but they should be in her courtroom. So that's Judge Alicia Jones Coleman. I'm Judge Donald Coleman. We're not related, but she happens to have the last name Coleman.
And her phone number is 965-2292.
And her phone number is 2292. Ma'am, I gave you 2404. So our phone number is 965-2292. 965-2292. Yes.
Yeah.
You both know.
Is there somebody else on Zoom?
Good morning. Good morning to you, sir.
Galaxy A02.
You met his something down there on the first floor.
No, he came up here in the hallway and she addressed him, let him know.
Let me see what you want. I got a couple.
Okay.
Open the door, let me see it. Let me wait there and say, actually.
Okay.
Hey, boy. How you doing? We all shut down and stuff, so they're gonna put you out. You can't come all the way up here.
Oh, okay.
How you been?
I've been okay. I come by the house the other day, I see the car, nobody come to the door, I don't think he was there.
Probably wasn't, there's usually somebody there, but, yeah, I don't know. Ain't no telling where I was.
Yeah.
If I hadn't seen you, man, you had me worried, because I ain't heard from you.
Oh, man, you sound good, man, you sound good.
Okay.
I couldn't remember, I don't think I remember that 506.
Yeah, 5251.
Huh? 5251.
Yeah.
I was right.
Yeah.
All right, I'm gonna call you, I know you're busy, but
Okay.
I need to talk to you, get time to talk, okay?
Okay, I
All
got
right,
you. I got
thank
your
you,
number
man.
here. All right,
All right.
you take care. Good to see you.
Good to see you too. Happy New Year's.
All right, yes, sir.
For the record, I'm an old man too. I'm old.
Yeah. Go on, boy.
45 years.